The slow, deliberate approach in the side mirror. The sudden, stomach-dropping realization that the swirl of red and blue is for you. A traffic stop is a universal moment of anxiety, a sudden intrusion of authority into the mundane rhythm of our day. In that pressured moment, governed by adrenaline and a desire to simply make it end, an overwhelming majority of drivers, a staggering 90% by many defense attorneys' estimations, commit a single, profound error. This mistake isn't rude or aggressive. In fact, it's usually made with the best of polite, cooperative intentions. But it systematically dismantles their legal position, turning a minor citation into a potential conviction and a simple warning into a costly, life-altering legal ordeal. I'm a lawyer, and that critical mistake is this. They talk too much, and they consent too quickly. This article is not about evading law enforcement or fostering disrespect. It is about understanding the constitutional architecture of a traffic stop, the psychology of the interaction, and the practical, legal leverage every citizen possesses, but nearly everyone surrenders without a thought. We will dissect the anatomy of a stop from the moment those lights appear to the final drive safe, arming you with knowledge, not attitude. The goal is to transform you from a passive subject of an investigation into an informed participant who can protect your rights without compromising your safety or courtesy. The anatomy of a traffic stop, a legal microcosm. A traffic stop is not a casual conversation. Under the law, it is a brief investigatory detention, a Terry stop, named after Terry versus Ohio, 1968. This means an officer must have reasonable articulable suspicion, RAS, that a traffic or equipment violation has occurred or that criminal activity is afoot to initiate the stop. The stop's scope and duration must be reasonably related to the initial purpose for the stop. However, within that narrow frame, the power dynamic is inherently skewed. The officer is on duty, trained, and in control of the narrative. You are startled, possibly embarrassed, and acutely aware of the officer's authority. The initial moments are scripted, the request for license, registration, and proof of insurance. Compliance here is legally required and non-negotiable. The trouble begins with the next, seemingly innocent question. Do you know why I stopped you today? This is not a search for information. It is a diagnostic tool. Your answer provides immediate, admissible evidence. Guessing wrong, was I speeding, can be construed as an admission. Offering a possible violation the officer hadn't even noticed, was it my broken tail light? Expands the scope of the stop. A common, polite deflection is, no, officer, I'm not sure. This is a neutral, non-adversarial response that forces the officer to state his RAS on the record. It sets a tone of calm, respectful awareness. The fatal cascade, volunteering and consenting. From this point, the 90% mistake unfolds in two acts: voluntary speech and unnecessary consent. Act 1. The chatter. Nervousness breeds chatter. The officer returns to your window, and the questions begin, often framed as friendly conversation. Where are you headed tonight? Have you had anything to drink this evening? Do you have anything in the car I should know about? These are investigatory questions, moving beyond the mission of writing a ticket for a lane change or speeding. They are fishing expeditions designed to elicit probable cause for a deeper investigation. Every innocent detail you offer, just coming from a friend's barbecue, or no, just some groceries in the back, is data collected. Inconsistencies, nervousness in your voice, or the mere odor of a legal substance can be woven into a justification for prolonging the stop. The legal truth is stark. You have an absolute Fifth Amendment right to remain silent. You must identify yourself when lawfully asked via your documents, but you're not required to answer investigatory questions about your travels, your activities, or your personal life. Invoking this right must be done unequivocally, but politely. Officer, I respect your job, but on the advice of counsel, I choose to remain silent on any questions beyond providing my documents. Will this alter the dynamic? Yes. It may frustrate the officer, but it also halts the expansion of the investigation. It builds a firewall around the initial, limited purpose of the stop. The Supreme Court has repeatedly affirmed Birkener v. McCarty, Salinas versus Texas, that silence, if not expressly invoked, can be used against you. You must speak to protect your right not to speak. Act 2. The premature yes. This is the crux of the error. The officer returns your documents, and you breathe a sigh of relief, thinking it's over. Then comes the ask, "You don't mind if I take a quick look around your car, do you?" The phrasing is deliberate. It's framed as a courtesy, a casual request. The social pressure to be agreeable, to prove you have nothing to hide, is immense. This is where 90% of drivers say, "Sure, go ahead," or "No problem." In doing so, they have just given voluntary consent to a search, waiving their Fourth Amendment protection against unreasonable searches and seizures. Here is the critical legal principle. Without probable cause, an officer needs your explicit consent to search your vehicle during a routine traffic stop. By granting it, you have handed over a right the Constitution specifically designed to protect you. Anything found, a forgotten prescription bottle, a legal but suspicious tool, a minuscule amount of contraband residue, becomes admissible evidence, all because of that one reflexive word, yes. You have the right to say no. You can do so respectfully and firmly. "Officer, I do not consent to any searches of my vehicle. Does this mean you'll be searched anyway?" Possibly. The officer may then have to develop probable cause through other means, e.g., calling for a canine unit, which is limited by the duration of the stop. Rodriguez versus United States. But if they proceed without your consent or without independent probable cause, any evidence found may be suppressed later in court, the famous fruit of the poisonous tree doctrine. Your refusal preserves your legal challenge for a later date. Your consent extinguishes it forever. The domino effect, how one mistake unfolds. Let's trace the typical disastrous sequence. The stop, speeding 10 over. The question, "Do you know why I stopped you?" Driver, "I was speeding, wasn't I?" "Sorry, I'm just tired from the party." The expansion, "Party, huh? Had anything to drink?" Driver, "Wanted to seem honest. Just one beer like 3 hours ago." The pivot, officer now has a potential DUI investigation. He asks driver to step out. He notices nervous behavior. The request, "Mind if I check your car real quick? Just to be safe." Eager to comply driver, "No, not at all. Go for it." The discovery, under the passenger seat, the officer finds a friend's leftover, half-smoked joint from a legal state, now a felony possession in your current jurisdiction. The result, the speeding ticket is the least of your worries. You are now under arrest for drug possession. Your admission about drinking leads to a DUI investigation. Your consent made the search legal. Every piece of evidence is admissible. Had the driver simply handed over documents, remained silent beyond identification, and refused the search, the outcome is vastly different. At worst, a speeding ticket. The constitutional barriers would have remained intact. A question of psychology and power. Why do we do this? The psychology is complex. We are conditioned to view authority figures as ultimately fair and to believe that transparency is the best policy. We fear that asserting rights looks guilty. This is a profound miscalculation. Law enforcement's duty is to investigate and build cases. Your duty is to protect yourself within the bounds of the law. These are not mutually exclusive, but they are different. The officer's goal is not to be your friend or your legal advisor. Their goal is to determine if a crime has occurred. Providing them with extra evidence against yourself is not in your interest. So, let me pose a suspense-driven question to you, the reader, that I want you to answer in the comments based on what you've learned so far. You're stopped for a faulty brake light. You provide your documents and remain politely silent. The officer, after a long pause, says, "Your eyes look a little red. Have you been smoking marijuana tonight?" If you answer no, you're potentially lying if you have, even legally. If you say yes or explain, you've just given probable cause. What is the single legally safest phrase you can say in that exact moment to protect yourself? Practical protocol, a step-by-step guide. Prepare. Have your license, registration, and insurance easily accessible before you're even stopped. Turn on your dome light, if at night. Keep hands visible on the wheel. The initial exchange, Provide documents when asked. You can offer a polite greeting. The why question, respond neutrally. I'm not sure, officer. Investigatory questions. Politely invoke your right. I prefer not to answer any questions, thanks. Am I free to go? Note: asking if you're free to go establishes whether you're still being detained. If not, you can leave. The search request. Decline clearly and calmly. I do not consent to any searches. Detention. If ordered out of the car, comply calmly. You can still refuse consent and remain silent. If arrested, state clearly, I am invoking my right to remain silent, and I want to speak to a lawyer. Then, truly remain silent. Throughout, be calm, respectful, and physically non-threatening. Your demeanor is part of your defense. Record the interaction if your state law permits. Audio recording on a phone is often legal. The goal is not to win the roadside encounter. The goal is to survive it without creating irreversible evidence against yourself. Preserving all your legal defenses for the arena where they matter, a court of law. Conclusion: knowledge as your best defense. A traffic stop is a short, high-stakes legal proceeding conducted on the shoulder of a road. The mistake 90% of drivers make is treating it like a social interaction where cooperation is always rewarded. In reality, it is a tactical investigation where constitutional rights are your primary assets. Volunteering information and consenting to searches is the legal equivalent of handing your opponent your best weapons in a duel. You can be both respectful and resolute. You can comply with lawful orders while refusing to assist in your own potential prosecution. The balance of power in that interaction is not as lopsided as it feels. Your knowledge of the law and the quiet courage to exercise it is the great equalizer. The next time you see those lights in your mirror, remember, your mission is not to chat. Your mission is to provide the legally required documents, to not incriminate yourself, and to protect the privacy of your vehicle from a warrantless intrusion. Do that, and you instantly separate yourself from the 90% who unknowingly pave the path to their own conviction. If you found this detailed guide to your constitutional rights during a traffic stop valuable, imagine what other legal myths and practical self-defense strategies we could debunk for you. Your safety and freedom shouldn't depend on luck or misinformation. For clear, actionable legal knowledge straight from the courtroom, be sure to subscribe to the channel. Hit that subscribe button and turn on notifications, because your next click could be the one that protects your future.